Imagine fleeing violence, persecution, and fear in your home country, going through one of the most exhaustive vetting processes in the world, being admitted to the United States as a refugee, spending a year rebuilding your life from nothing, finding a job, enrolling your children in school, learning English, and doing everything right, and then being told that when you apply for the green card you were promised by law you could be detained. Not because you have done anything wrong, not because there is any evidence against you, but because the government is implementing a new policy of re-screening refugees during the green card application process, and that re-screening could include detention without bond while your case is reviewed. That scenario is not hypothetical. It is what is now potentially facing tens of thousands of refugees who are legally residing in the United States and who were counting on a straightforward transition to lawful permanent residence as the next step in their legal journey. Today, we are covering one of the most significant and most alarming changes to the refugee immigration system in recent memory. And we are going to break down exactly what is happening, who is affected, what the legal landscape looks like, and what refugees and their advocates need to know and do right now. Hello, everyone, and welcome back to U.S. Benefits Update. I am your host, Claire Hollister, and thank you so much for being here with us today. This channel is committed to bringing you the clearest and most complete information about immigration policy changes, government benefits, and the legal developments that directly affect the lives of people across the United States. Today, we are covering a topic that sits at the intersection of immigration law, refugee protection, civil liberties, and national security, and it is a topic where the stakes could not be higher for the people involved. We understand that this is a subject that carries enormous emotional weight for many of our viewers, and we are going to approach it with the care, the accuracy, and the completeness it deserves. Please stay with us all the way through this video, because every section contains information that builds on what came before, and the full picture is essential for anyone who is navigating this situation or who wants to understand it. Here is what we know about the new policy that is affecting refugees who are in the process of applying for lawful permanent residence. The Department of Homeland Security, acting through United States Citizenship and Immigration Services and Immigration and Customs Enforcement, has been implementing a policy framework that subjects refugees who are applying for adjustment of status to green card status to an enhanced re-screening process. This rescreening is being conducted with the stated purpose of identifying fraud in the refugee admission system and ensuring that individuals who were admitted as refugees genuinely met the legal definition of a refugee at the time they were admitted and continue to meet it. The most alarming aspect of this new policy for the refugee community and for immigration law professionals is the detention component. Under the framework being implemented, refugees who are flagged during the rescreening process may be subject to detention by immigration and customs enforcement without being offered a bond hearing, meaning they could be held in immigration detention while their rescreening is conducted without any judicial review of whether detention is necessary or appropriate in their specific case. This represents a dramatic departure from the standard immigration detention framework, which generally requires a bond hearing before an immigration judge within a reasonable period of time for individuals who are detained. The policy has generated immediate and significant alarm from immigration attorneys, refugee resettlement organizations, civil liberties advocates, members of Congress, and international human rights organizations. Critics argue that subjecting refugees who have been lawfully present in the United States for a year, who have been building their lives and contributing to their communities, and who have a statutory right to apply for a green card, to detention without bond during a rescreening process is both legally questionable and deeply contrary to the humanitarian principles that underlie the refugee protection system. Supporters of the policy argue that it is a necessary measure to ensure the integrity of the refugee system and to identify individuals who may have obtained refugee status through fraud or misrepresentation. The scope of the potential impact is significant. Under U.S. law, refugees are required to apply for a green card after 1 year of continuous presence in the United States, and the legal obligation to apply is not optional. Refugees who fail to apply within the required timeframe can lose certain immigration benefits and may face complications in their legal status. This means that the universe of people potentially subject to this rescreening process includes not just those who voluntarily choose to apply early, but all refugees who have been in the United States for approximately 1 year or more, and who need to comply with the legal requirement to adjust their status. To understand why this policy is being implemented and why it is so significant, we need to look at the legal framework that governs refugee status and the path from refugee admission to lawful permanent residence, as well as the broader policy context in which this change is being made. The refugee program in the United States operates under a specific legal framework that is distinct from other forms of immigration, and understanding that framework is essential for making sense of what is happening. The United States Refugee Program is governed by the Refugee Act of 1980, which established the legal definition of a refugee in domestic law and created the current system for admitting and resettling refugees. Under the Refugee Act, a refugee is defined as a person who is unable or unwilling to return to their home country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. This definition aligns with the 1951 Refugee Convention and its 1967 Protocol, which are the foundational international legal instruments governing refugee protection. The process of being admitted to the United States as a refugee is, by virtually any measure, the most extensive and rigorous vetting process applied to any category of person seeking to enter the country. Before a refugee is admitted, they undergo multiple rounds of background checks conducted by USCIS, the State Department, the National Counterterrorism Center, the FBI, the Department of Defense, and other intelligence and law enforcement agencies. They are interviewed by USCIS officers who assess the credibility of their refugee claim. They undergo biometric screening, medical examinations, and cultural orientation programs. The entire process typically takes 18 months to 2 years or more, and the acceptance rate is a small fraction of the people who are referred for consideration. The system was designed precisely to ensure that the people who are admitted genuinely meet the legal definition of a refugee and do not pose a security threat. After a refugee is admitted to the United States, they are eligible to access a range of resettlement services, including temporary housing assistance, employment services, English language instruction, and other support programs that are designed to help them become self-sufficient as quickly as possible. The legal pathway from refugee status to permanent residence is clearly established in the law. Under Section 209 of the Immigration and Nationality Act, refugees are entitled to apply for adjustment of status to lawful permanent resident after 1 year of continuous presence in the United States, and the law requires them to do so. This adjustment of status to green card is the mechanism by which the refugee's temporary protected status is converted into the more permanent status of lawful permanent resident, which then puts them on the pathway to eventual citizenship. The new rescreening policy being implemented by the current administration reflects a stated concern that the refugee admissions process, despite its rigor, may have allowed some individuals who did not genuinely qualify as refugees to be admitted, whether through fraud, misrepresentation, or errors in the original adjudication. The administration has also pointed to the general principle that the circumstances that led to a person being granted refugee status should be verified at the point of the green card application to ensure that the original determination was correct and that the person's situation has not materially changed in ways that would affect their continued eligibility. This is the stated rationale for the rescreening, though critics argue that the existing vetting processes are already more than sufficient and that the rescreening represents not a genuine fraud detection measure, but a broader effort to reduce the overall presence of refugees in the United States. Let us now be very specific about who is affected by these changes and what the scope of the population at risk looks like, because precision here is essential for refugees and their legal representatives who need to assess their individual situations. The policy, as described, applies to refugees who have been admitted to the United States under the U.S. Refugee Admissions Program and who are in the process of applying for or are approaching the point of needing to apply for adjustment of status to lawful permanent residence. This means individuals who were admitted as refugees approximately 1 year ago or more and who need to file the Form I-485 application to register permanent residence or adjust status. All nationalities within the refugee population may potentially be subject to enhanced rescreening, though the degree of scrutiny and the likelihood of being flagged for the most intensive elements of the rescreening process, including potential detention, may vary based on the applicant's country of origin, the specific basis of their refugee claim, and any information that emerges during the background check process. Asylees, meaning individuals who were granted asylum status within the United States after arriving and applying for protection rather than being admitted through the Overseas Refugee Program, face a somewhat different but related set of issues. While the specific details of the rescreening policy as announced focus on refugees admitted through the Overseas Program, immigration attorneys have noted that the broader policy direction raises questions about the adjustment of status process for asylees as well, and anyone in either category who is approaching their green card application should consult with a qualified immigration attorney before filing. Refugees who have special immigration status categories, including certain Afghan and Iraqi nationals who came to the United States under special immigrant visa programs rather than strictly through the refugee program, need to carefully assess how the new policies apply to their specific status category. The rules governing these special immigrant categories differ in some respects from those governing standard refugee admissions, and the rescreening policy may apply differently or not at all to individuals in these categories. Again, consultation with a qualified attorney is essential for anyone in these categories who is planning their green card application. Children who were admitted as refugees and who are now approaching their 1-year anniversary of admission present a particular situation because the legal and practical implications of detention for minor children are distinct from those for adults and raise specific concerns under both domestic law and international obligations regarding the treatment of refugee children. Parents of refugee children who are approaching their green card filing deadline should seek legal counsel immediately to understand the implications for their family. One of the most important things we can do for refugees and their families in this video is to clearly explain what legal rights exist and what the legal challenges to this policy look like, because understanding the legal landscape is essential for navigating the situation effectively. The legal issues raised by the detention without bond component of this policy in particular are significant and are being actively litigated in federal courts. The right to a bond hearing is a foundational protection in the immigration detention context. Under existing Supreme Court and Circuit Court precedent, most individuals in immigration detention are entitled to a hearing before an immigration judge at which the government must justify continued detention, and the individual has the opportunity to argue for release on bond or on their own recognizance. The government's position that refugees in rescreening can be held without bond challenges this framework by arguing that the detention is justified by the nature of the rescreening process and the security concerns it is designed to address. Immigration law scholars and civil liberties attorneys have argued forcefully that this position is legally incorrect and that the due process protections that apply to immigration detention do not disappear simply because the detainee is a refugee who is being rescreened. There is also a strong argument rooted in the specific statutory protections that apply to refugees. The Refugee Act of 1980 and the broader framework of U.S. refugee law reflects commitments made under international law, including the principle of non-refoulement, which prohibits the return of refugees to situations where they face persecution. While the detention component of the rescreening policy does not by itself constitute refoulement, attorneys have argued that the conditions of detention and the potential outcomes of the rescreening process raise concerns about whether the overall policy framework is consistent with U.S. obligations under refugee law. Multiple civil liberties organizations, including the American Civil Liberties Union, Human Rights First, the International Rescue Committee, and various refugee legal services organizations, have filed or are preparing to file legal challenges to various aspects of the rescreening policy. These challenges are proceeding on multiple legal theories, including due process, statutory interpretation of the refugee adjustment of status provisions, and international law obligations. The outcomes of these legal challenges could significantly affect how the policy is implemented and what rights refugees have during the rescreening process, and affected individuals and their attorneys should monitor these cases closely for developments that could affect their situations. To fully understand what is at stake for refugees who are facing this new policy, we need to be clear about what lawful permanent residence, the green card, provides and why the transition from refugee status to lawful permanent resident status is so critical for these individuals and their families. Lawful permanent residence provides a level of stability and security that refugee status alone does not fully provide. As a lawful permanent resident, a refugee can live and work in the United States on a permanent basis without the temporal limitations associated with some aspects of refugee status. They can travel internationally and return to the United States with a green card, which is more straightforward than traveling on refugee travel documents. They can sponsor certain family members for immigration benefits, including spouses and unmarried children. And after 5 years of lawful permanent residence, they can apply for U.S. citizenship, which is the ultimate form of security and belonging in the country. The ability to sponsor family members is particularly significant for refugees because many refugees were forced to flee their home countries without their entire families, leaving spouses, children, parents, and siblings behind in dangerous situations. The green card is the gateway to eventually being able to petition for these family members through the family-based immigration system, and a delay or denial of the green card application therefore has cascading consequences not just for the refugee but for the family members who are counting on their relatives' ability to petition for them. For refugees who are employed, particularly those who have found jobs in fields where immigration status is a factor in employment eligibility or professional licensing, the transition from refugee status to lawful permanent resident status can also be important for career advancement and professional stability. Some professional licenses and some employment categories have eligibility requirements tied to immigration status, and obtaining lawful permanent residence removes certain limitations that refugee status may impose. The stakes of potential detention during the green card application process extend beyond the individual to their entire family and community network. Refugees who have spent a year establishing themselves, finding employment, enrolling their children in school, and building community ties stand to lose all of that progress if they are detained for an extended period during a rescreening process. The loss of employment during a detention period, the disruption to children's schooling and lives, and the trauma of detention for individuals who have already experienced significant trauma in their flight from persecution represent costs that go far beyond the legal and administrative dimensions of the policy. Understanding the timeline of the rescreening policy and the critical deadlines that refugees need to be aware of is essential for planning and for taking protective action before filing a green card application. Let us walk through the key timing elements that every refugee and their legal representative needs to understand. The statutory requirement for refugees to apply for a green card is clear. Refugees are required to apply for adjustment of status after 1 year of continuous presence in the United States, and the application must generally be filed within a specific window around the anniversary of their admission date. Failure to apply within the required time frame can result in the loss of certain benefits and can create complications in the refugee's legal status. This means that regardless of concerns about the rescreening policy, refugees who are reaching the one-year mark of their admission to the United States cannot simply choose not to file their green card application. The legal obligation to file exists, and failure to comply with it creates its own risks. The practical implication of this is that refugees who are approaching the one-year anniversary of their admission need to be consulting with an immigration attorney as early as possible, ideally several months before the filing deadline, to assess their individual situation, understand the current state of the rescreening policy, review their case for any potential issues that might trigger enhanced scrutiny, and develop a filing strategy that minimizes their risk exposure. Early consultation is not optional in the current environment. It is essential. The rescreening process, once triggered by a green card application, does not have a publicly announced timeline for completion. This is one of the most stressful aspects of the policy for refugees and their families, because there is no clear endpoint visible at the start of the process. Immigration attorneys have reported significant variation in how quickly rescreening processes are being completed for different individuals, with some cases moving relatively quickly and others remaining in review for extended periods. The absence of a defined timeline creates uncertainty that affects every aspect of a refugee's life planning. For refugees who are currently in detention as a result of this rescreening policy, the most urgent timeline priority is obtaining legal representation as quickly as possible. Immigration court proceedings have their own deadlines, and failure to have legal representation in place quickly can result in cases moving forward in ways that are disadvantageous to the detained individual. If you or someone you know is a refugee who has been detained in connection with a green card application rescreening, the single most important immediate action is to contact an immigration attorney or a refugee legal services organization immediately. Looking at the broader timeline of this policy, the legal challenges that have been filed and that are being prepared will move through the federal courts over the coming months and potentially years. Court decisions could significantly modify how the policy is implemented, what rights refugees have during the process, and potentially whether certain aspects of the policy survive legal scrutiny at all. Refugees and their advocates should monitor these legal developments closely, as court orders in these cases could affect the rights of all refugees in similar situations. The response from immigration law experts, refugee protection specialists, human rights organizations, and policy analysts has been extensive and largely critical of the detention component of this policy, though the conversation includes a range of perspectives that are important to understand fully and fairly. Immigration law professors and scholars who specialize in refugee law have published detailed legal analyses arguing that the detention without bond component of the rescreening policy is inconsistent with both the statutory framework of U.S. refugee law and the constitutional due process protections that apply to individuals in immigration detention. These scholars point to the long-standing legal principle that immigration detention is not punitive in nature, and that the government must justify continued detention through an individualized assessment of flight risk and danger to the community, not through a blanket policy applied to entire categories of applicants. The argument that refugees who have been lawfully present for a year and who are legally obligated to apply for a green card can be detained without bond simply because they have filed the application they are required to file strikes many legal scholars as legally indefensible. Refugee resettlement organizations, which work directly with refugees on a daily basis and have deep knowledge of the population and its circumstances, have been among the most vocal and most comprehensive critics of the policy. Organizations like the International Rescue Committee, the Hebrew Immigrant Aid Society, Lutheran Immigration and Refugee Service, and dozens of other resettlement agencies have issued public statements, testified before Congress, and engaged directly with government officials to communicate the devastating potential impact of the detention policy on the refugee community. These organizations argue that the fraud detection rationale for the policy does not justify the breadth and severity of the approach being taken, and that the evidence base for widespread fraud in the refugee admission process does not support a policy of potential detention for all applicants. National security analysts who support stricter vetting of immigration applicants have offered a more sympathetic perspective on the fraud detection rationale for the rescreening policy, while some have also expressed concern about the detention mechanism specifically. These analysts generally agree that ongoing verification of immigration status claims is a legitimate governmental interest and that discovering and addressing fraud in the refugee system is important for the integrity of the program. However, even within this camp, there are voices questioning whether detention without bond is the appropriate mechanism for addressing fraud concerns, particularly when less drastic alternatives, such as enhanced documentary review, in-person interviews, and reporting requirements, could potentially achieve the same fraud detection objectives without the severe consequences of detention. International human rights bodies, including the United Nations High Commissioner for Refugees, which is the UN agency responsible for protecting refugees worldwide, have expressed concern about the direction of U.S. refugee policy under the current administration, including the rescreening policy. The UNHCR has long-standing guidelines on the detention of asylum seekers and refugees, which establish that detention should be used only as a last resort, that it should be subject to meaningful judicial review, and that it should not be imposed on the basis of refugee status alone. U.S. obligations under the Refugee Convention and its protocol, while not directly enforceable in U.S. courts in all circumstances, provide an important normative framework against which domestic policy should be evaluated, and the UNHCR's concerns reflect the view that the current U.S. approach is moving away from the international standards that the United States helped establish. Let us now spend time on the real human dimension of this policy, because the legal and policy debates, as important as they are, can sometimes obscure the very human stakes of what is happening. The refugees who are affected by this policy are not abstractions. They are people with names, with families, with children in American schools, with jobs, with friendships, with community ties, and with the same basic human hopes and fears that all people carry. Before we close out today, we want to hear from you. Are you a refugee who is approaching your green card application deadline and has questions about the rescreening policy? Are you an immigration attorney or legal aid worker who is working with refugees affected by this policy and has information or guidance to share with our community? Are you a community member or advocate who wants to understand how to support refugees in your community who are navigating this situation? Please share your questions, your experiences, and your resources in the comments section below. The information that our community shares in the comments is genuinely valuable, and this is one of those situations where community knowledge and shared resources can make a real difference in people's lives. If this video helped you understand the refugee green card rescreening policy more clearly and gave you information that is genuinely useful for navigating this situation, please take a moment right now to give it a thumbs up and to share it with every refugee community member, resettlement agency, and advocate in your network. The information in this video is urgent and time-sensitive, and making sure it reaches the people who need it is one of the most important things our community can do. If you are not yet subscribed to U.S. Benefits Update, please subscribe right now and turn on your notification bell so you receive an alert every time we publish a new video. We are covering every significant development in this situation and in the broader immigration landscape as it evolves, and staying informed is the most important protective step anyone in the affected community can take. I am Claire Hollister, and on behalf of everyone here at U.S. Benefits Update, thank you for watching today. We stand with every refugee who is navigating this difficult situation, and we will be here with information and updates every step of the way. We will see you in the very next video.